when a senior director slides a folder across the table. Inside is a request for a sizable sum of company money to purchase a personal house. You need to make a decision. Approving that request without consulting Section 185 of the Companies Act 2013 is a severe compliance risk. If you misstep here, the company faces heavy fines, and the officers authorizing the transaction could face imprisonment. The Indian legislature drafted Section 185 with a very specific intent: to prevent controlling individuals from draining corporate funds to serve their personal interests. To navigate these rules safely, we are going to build a 4-part loan eligibility checklist. By the end of this evaluation, you will have a clear system to process any executive loan request legally. Internalizing this framework ensures you protect the financial integrity of the business while insulating yourself from personal legal liability. Let's start with the first hurdle. Step 1 is the prohibition check, starting with the identity of the person asking for money. The law instantly restricts financial backing if the recipient is a director, their relative, business partner, or a related firm. This net covers all entities and restricts multiple types of financial backing. You are prohibited from issuing direct cash loans, registering loans as book debts, or providing a corporate guarantee to an external bank on behalf of that director. Proceeding with any of these transactions invites immediate penalties for every officer in default. If your scenario involves a restricted recipient and a restricted transaction, the request is dead on arrival, unless you can pass the rigorous exception test. Step 2 of our checklist is the exception test. Here, the law provides a few narrow pathways to turn a prohibited loan into a legally permissible one. The first pathway applies exclusively to managing or whole-time directors. The loan must be granted as part of their ordinary conditions of service. This covers routine professional allowances, like standard travel advances or corporate relocation expenses. You cannot use this exception to grant a personal financial favor. The second legal pathway is the employee welfare exception. This allows you to grant a loan to a director, provided they are also an employee. The mandatory condition here is that the loan must fall under a bona fide company-wide scheme. That means the money is tied to specific policy-defined life events, like a medical emergency or higher education costs. In short, to clear Step 2, you must prove the transaction serves an established corporate policy, completely detached from executive privilege. The most common compliance failure happens when a company tries to disguise a personal loan as a housing scheme. The stated purpose of the money matters far less than the company's established framework. Look at this split screen. On the left, Company A grants a direct 20 lakh rupee loan to Director X to buy a house. This fails the Section 185 test immediately. On the right, Company B issues a housing loan to Director Y. However, Director Y applied through a pre-existing employee welfare scheme, using the exact terms offered to the rest of the staff. This is a structural problem. Legality relies entirely on treating the director exactly like any other employee under a documented, auditable scheme. Step 3 is execution. Passing the initial tests means nothing without the correct legal paperwork. This flowchart outlines your final procedural requirements. If your loan qualifies under Path A, meaning it fits a recognized exception, you must convene a board meeting and ensure every detail of the welfare scheme is rigorously documented and auditable. The critical trap in Path A occurs at the voting stage. The interested director must formally disclose their interest in the transaction and absolutely recuse themselves from the vote. If your transaction doesn't fit an exception, you move to Path B. This requires convening a general meeting to pass a special resolution, which you must then file directly with the Registrar of Companies. Missing that ROC filing instantly turns a permissible loan back into a penal offense. Procedural execution is non-negotiable. Here is our completed Section 185 framework. You evaluate the recipient, verify the transaction type, apply the exception test, and execute the proper procedural path. By following these 4 distinct steps, you eliminate guesswork from high-stakes boardroom decisions. You can